Welcome back, everyone, for day two of navigating mainstream benefits of SSDI and SSI. Again, my name is Ansu Anderson. I'm an attorney at the Health Program of the Law Foundation of Silicon Valley. Just a little bit about the Law Foundation of Silicon Valley. Apologies for duplication for those of you who were here yesterday. The Law Foundation provides free legal services in three subject areas: health, housing, and children and youth. Our health practice focuses on providing legal services to people living with physical and mental health disabilities in a variety of practice areas, including mental health patients' rights, public benefits like Social Security, state and local benefits like Medi-Cal, GA, CalFresh, federal student loan discharges, as well as name and gender marker changes. Just a roadmap about what we'll be covering today. We're going to be focusing on post-eligibility issues. That's eligibility issues that come up after your client has been approved for SSI or SSDI, including health insurance linked to Social Security benefits, questions about representative payees, living arrangements and their effects on SSI, continuing disability reviews, incarceration and the impacts on your benefits, working while receiving benefits, as well as overpayments. Just as a caveat, like yesterday before we begin, Social Security has a lot of complex rules that are frustrating, confusing, and hard to understand. You don't need to memorize all the information I'm sharing today. Our goal is to give you this information so you can help people identify the issues as they come up, and so you'll know also when to refer clients for our help. Bottom line, if your client gets a notice from Social Security that you don't understand, or your client has a problem with Social Security, we're here to help. Interacting with Social Security can be difficult. It's difficult for everyone, including myself. This, unfortunately, is not something we can fix. We only hope to partner with you as well as assist your clients in supporting their journeys on getting SSI or resolving issues with SSI and SSDI. But just, I think everyone is aware that it can be very difficult to deal with Social Security at times. So that's something that, yeah, is a little bit out of our control. So today is going to be focused on your client and issues that maybe come up after they're approved for benefits, aka post-eligibility issues. Starting off, we're going to talk about health insurance tied to SSDI, Supplemental Security Disability Income. And so we'll be discussing when does access to Medicare begin. An individual is eligible for Medicare 2 years after they're entitled to SSI. So 2 years after their SSDI, begins. There is a 5-month waiting period. So entitlement to SSDI begins 5 months after the date of the onset of date of disability. Therefore, an individual is actually entitled to Medicare 2 years and 5 months after the onset of disability. There are efforts in Congress right now to try and change that 5-month waiting period, but just so you know, often 17 months is a key timeline in order for someone to access their Medicare benefit. Although an individual qualifies for Medicare 2 years after their SSDI entitlement, Medicare coverage may come with a cost. Medicare Part A, which is hospital coverage. Let me give an overview first. So Medicare Part A is hospital coverage. Then we'll be discussing Medicare Part B, which is outpatient coverage, for like clinic services and seeing your primary care physician, for example. And then we'll be talking a little bit about Medicare Part D, which is prescription drug coverage. If an individual is fully insured, in other words, they've worked 40 quarters and hit the minimum in order to be insured by Social Security, then Medicare Part A is free. For people on disability who are not fully insured, there's a premium of $278 per month for people with 30 to 39 work quarters, and a higher premium of $506 for people with fewer than 30 quarters of work earnings. Furthermore, a deductible may also apply. Talking a little bit about Medicare Part B now, individuals typically pay Part B premium of $174.70, and here a deductible may also apply. When it comes to Part D coverage, that's coverage for your prescription drugs. Depends on the plan that you purchase. If clients have questions about this, they can call our office, or you can write a referral to our office, and we can often either help counsel them or refer them to nonprofit organizations who specialize in helping people find plans. People who are low income may qualify for state-sponsored MSPs, Medicare Saving Programs, which will pay Part A and Part B premiums, copays, and deductibles. An individual who is eligible for SSI is automatically eligible for SSI-linked Medi-Cal. So this means they don't have to complete renewal paperwork with the county. If you weren't on SSI, you may be familiar with that. This is Medi-Cal that comes automatically when you are awarded SSI. After Social Security has approved an individual's application for SSI benefits, Social Security will automatically report their Medi-Cal eligibility to the local social services office. So they don't need to do anything proactively to obtain those Medi-Cal benefits. Social Security goes ahead and sends off that notice of eligibility over to social services. Individuals who are approved for SSI do not need to apply for Medi-Cal separately. Medi-Cal coverage begins the same month the SSI benefits begin. It is possible to have social services to be approved for Medi-Cal through social services prior to being on SSI. And if you get on SSI after, Social Security will help switch them from regular Medi-Cal over to SSI-linked Medi-Cal. So that is also automatic. If an individual qualifies for Medi-Cal through SSI eligibility, they'll qualify for full scope Medi-Cal coverage. A little bit about representative payees. In some instances, Social Security decides that a person receiving SSI or SSDI is not capable of managing their money. If Social Security has determined that this is the case, a representative payee must be appointed. It is recommended that someone who is a close friend or family member serve as a payee. That way, if there's any problems or communication issues that arrive, it's someone that the client trusts, so they're able to work out their issues. However, if a beneficiary does not have a friend or family member willing to serve as their payee, Social Security looks for a qualified organization who will serve as a payee, and this does come with a small monthly fee. In San Jose, there's only one representative payee organization called Benefits Management Corporation. BMC typically charges approximately $40 a month to manage benefits, and that fee is deducted from their Social Security automatically if they sign on as their payee. There are friends and family that may be unwilling because a representative payee does have obligations once they sign on as someone else's payee. They need to receive the person's benefits. They need to help pay for their current needs out of their benefits. The payee needs to save for future needs that they may see coming. They need to provide spending money as needed. They need to keep records of money going in and out, as well as report the use of the funds to Social Security. Typically, it's not as you go per se, but it could be a summary form that Social Security will mail to the payee, and then they have to submit a response. And they also need to return overpayments to Social Security as well. If a beneficiary has a representative payee but feels like they can manage their own benefits, the beneficiary can actually file a request with Social Security to become their own representative payee. The beneficiary needs to go to the local Social Security office in person to start that application process. And Social Security will process the application and send a request to the beneficiary's doctor, asking if the beneficiary is mentally and physically capable of handling their own benefits. Our office has helpful information sheets little guides that can be provided for interested clients. So if you're interested in that, feel free to reach out to us or send a client to us and we can give that to them. Um, a little bit about living arrangements now and how that affects SSI. How much SSI a person receives each month is based on their living arrangement. For SSDI, it does not matter where the person lives. The amount will always be the same unless there's some sort of overpayment or other reduction. But for people on SSI, one's living arrangement can change how much they receive. And so because of this, it is very important that clients notify Social Security every time they move, so Social Security can update the living arrangement and decrease the cause of overpayments. If a person, for example, lives independently and they don't rely on anyone else for help with paying for their monthly expenses and they have their own cooking facilities, they should receive $1,233.94 in SSI benefits for 2026. If a person lives independently and does not have access to cooking facilities, for example, perhaps they're living somewhere where their oven is not working, or their refrigerator has been broken, or they're unhoused. Well, then they will be eligible for the homeless rate, which is a slightly larger amount to account for needing to purchase meals at restaurants or outside. So it goes a little bit higher to $1,362.81 for 2026. But you can see how if you're starting to get the homeless rate and for some reason your cooking facilities are repaired or you become housed and Social Security all this time has been paying you about $1,300 and they find out about it later on, they're going to say, oh, well, you owe us this money back, this extra $100 back for every single month. And it does accumulate quickly. So in order to avoid overpayments, it is very important that someone reports changes to their living arrangement as soon as possible. And there's actually a rule that Social Security provides to people when they become on SSI, or it's not provided to them per se, but it exists, which is they need to report any change within 10 days of that change. Staying at a shelter may still qualify a person for the homeless rate if 3 meals a day are not provided, or if they're not able to access potentially a shared kitchen or something like that. Social Security will reduce the amount of SSI a client receives if they live in another person's home and they pay less than their fair share of food and shelter costs. This is because Social Security has said that SSI is a benefit of last resort, as well as a social safety net program for food and shelter. So if someone else is paying for your food and or shelter, then they think that you do not need your SSI to the full amount. Social Security will also reduce your SSI if you live in your own home, but someone else pays for all of it or pays for part of your food, rent, or utilities. These are related to Social Security rules about what they call in-kind support and maintenance. Social Security will also reduce the amount of SSI someone receives if they're in a hospital or a nursing facility for 30 days or more. Again, the same reasoning applies because your food and shelter was taken care of, albeit not not a very hospitable environment per se. They still say, okay, if you're taken care of for 30 days or more on food and housing, then you do not need your SSI for that month. So it is important to report hospitalizations of 30 days or more to Social Security so that you avoid any overpayments in the future. In-kind support and maintenance is the key term here. We also call it ISM. That is defined as food or shelter costs that someone else pays for someone receiving SSI. There are exceptions, however. Federal housing subsidies or food stamps and the home energy assistance payments programs do not count by law. Shelter costs, including utility payments, count, but things like cell phone bills or cable bills, if someone else is paying for that, that doesn't count. It won't go towards a deduction in your SSI. And there's been a recent change in the law at the end of 2024. Effective September 30th, 2024, food is no longer included in these calculations. That means the value of food will no longer reduce SSI payments. So if someone is paying for your grocery bill, your SSI will not necessarily be decreased. Prior to this, it was definitely a factor in how much SSI you would receive. But under Social Security's rules, food is no longer included. You should still be careful though, and if you have any questions, please let us know because there are exceptions to that rule as well. Like if someone gives you a gift card for food, that gift card will be counted against your SSI. So again, just proceed with caution. If someone is thinking about getting something, you can always call our office and ask. Under Social Security's ISM rules, if someone helps a client pay for their rent, mortgage, food, or utilities, with a small caveat about food now, Social Security reduces the amount of their SSI benefits. There are complicated rules, as you have just seen, about exactly how much Social Security a person receiving ISM will be paid each month. But for the purposes of today's training, just know this general idea of in-kind support and maintenance, resulting in benefit reduction so that you're able to spot the issue and know when to refer someone, for further counseling. Now we have some examples here and feel free to add them into the chat. So Joe lives alone in an apartment. Joe's brother pays his full monthly rent amount of $1,200. Will Joe's SSI be reduced because of that in-kind support and maintenance? What do you all think? Yes. I see some yeses. I'm able to toggle back and forth. Yes, you all are correct. It will affect their SSI. Social Security will say, okay, your rent is being fully paid for, and so we will reduce your Social Security. Again, there's very complicated rules relating to if they live inside the home or outside the home, but it could be like a third reduction of their SSI, which is a significant amount. Thank you for participating via the chat. I really appreciate seeing the answers. Okay, next question. Maria lives alone in an apartment with a Section 8 voucher that requires her to pay 35% of her income towards rent. She pays her full rent portion on her own using her SSI money. Maria's parents pay her cable TV bill. Will her SSI be reduced because of in-kind support and maintenance? What do you all think here? Seeing a lot of no's, you all are correct. Remember, the Section 8 voucher is an exception. The federal subsidy program, you can have assistance from a government program such as that. Sometimes Social Security gets it wrong, so it's just a matter of clarifying with Social Security, hey, it's actually a Section 8 voucher that she receives. It's not someone else privately giving her money. And then if that's the case, no, her SSI will not be touched. How about the fact that Maria's parents pay her cable TV bill? Does that matter? No, does not. No for cable. You would be correct. That's just to throw you off. Utilities, yes, so gas, electric, but cable bill, cell phone bill, no, that will not affect their SSI. Um, and then, oh, I guess I preempted myself there. What if Maria's parents also pay her PG bill? Yes, it will affect her SSI. What if they buy her groceries? Will it affect her SSI? No, as of September 30th, it will not affect her SSI. September 30th, 2024. So good job to lawmakers that have changed that rule. All right, third hypothetical. Brandon lives with his brother and two sisters in a home that his brother owns. The mortgage payment is $3K a month, utilities are $300 a month, and household food costs are $600. The total household expenses are $3,900 for 4 people. What is Brandon's fair share of household expenses? You want to drop it into the chat? hard for me to read the chat here. Let me pull it down. Yep, 1/4 of it. Because there's 4 people in the household, divide it by 4. Okay. Will Brandon's SSI be reduced because he is receiving in-kind support and maintenance? No, you'd be correct. All right, so you're just going to divide by 4, and that's how they see whether or not you're paying your fair share.
And
Yeah.
for the second scenario, someone asked a question, what happens if the individual is receiving a 1-year housing subsidy from a nonprofit?
I'd have to look into the law on the nonprofit. Yeah.
And then another question, I think folks are just curious of, are any of these changes that were just implemented for 2026?
Mm-hmm. Yes. Yeah. So moving forward, as of 2020, September 30th, 2024, going on forward, unless someone changes the law again, it continues. Good question. Okay, moving on to continuing disability reviews. We talked a little bit about it yesterday, but diving deeper, Social Security conducts CDRs approximately every 3 years. It may be more frequent if a disability is expected to improve. Normally, the administrative law judge will note that in their decision, or Social Security will note that in someone's file. You may not always see it, it's in their internal paperwork. Social Security will notify the client by mail if they're reviewing their disability. We went over questionnaires yesterday, but client will have to fill out new questionnaires similar to the disability report or the function report that they filled out in the initial application. So they're just trying to get an idea of what is their day-to-day functioning like. There are 2 levels of appeal when you receive a review and a denial from that review. It's similar to the initial application. It's important to file an appeal within 15 days of receiving that, of the date of the denial, not the receipt of the denial, but the date of the denial. So you do everything possible to help them submit that appeal within 15 days. Otherwise, they could have their benefits stopped. There is good cause for late filing, but it still may result in a lapse of benefits. So it's that 15-day deadline is super critical because it gets a lot harder after that 15 days to get their benefits turned on, if at all. It may not be possible. Otherwise, just to say I disagree with that decision, the appeal deadline is the normal 65-day deadline. But to keep your benefits going while you're appealing and in this process of appeal, it has to be in within 15 days. Is that clear? Hopefully that's making sense. Okay, so a little bit about incarceration and their effect on benefits. SSDI and SSI payments generally are not payable for the months when an individual is incarcerated. If the client receives SSDI benefits, their money will be suspended if they're convicted of a criminal offense and sent to jail or prison for more than 30 days. So any type of incarceration pre-conviction does not count. Incarcerations for probation or parole do not count from the date of the order revoking probation or parole. The client's benefits can be reinstated with the month following the month of your release. Though clients cannot continue receiving SSDI benefits while they're incarcerated, their spouse and or children will continue to receive benefits as long as they are eligible. Okay, so these are rules that the effects of incarceration on SSDI. Now we're going to move to SSI. So if you're incarcerated and you're receiving SSI, their payments are suspended if you're incarcerated for a full calendar month. Unlike SSDI, conviction does not matter. Your SSI, again, remember that's that food and shelter. It doesn't have to be ideal food and shelter. It's just the fact that it's taken care of. So even if there's no conviction there, they're going to take away the SSI benefit for that month. Their payments can be reinstated in the same month unless in the same month they're released, unless the incarceration lasts for 12 consecutive months or longer. Okay. So if someone's in and out of jail and it's been less than 12 months, you can get it reinstated. If the incarceration lasts for 12 months or more consecutively, there might be bigger problems. You might have to ask them to reapply. If you're not sure, you want to get in and out dates, records, things like that, feel free to contact our organization for help. It's important to tell the client that about Social Security rules and about when they're to tell Social Security about when they're released and to provide those documentation dates of incarceration so they're not negatively affected by their incarceration. And if the client is incarcerated for 12 months or longer, unfortunately, they're going to have to reapply for Social Security benefits, which is very unfortunate. They'll have to start that process all over again. Yeah, the best thing to do is as soon as you know about someone being released, like telling them, hey, let's try and get your in and out dates and get you back on benefits as soon as possible. Because it's not only being incarcerated for 12 months or more, it's being out of pay for 12 months or more consecutively as well. That will cause your client to need to reapply for benefits. And reapplying means they're going to do a whole medical determination again. So it really is an onerous process to have to restart all over again. Okay, a little stop here for questions. Any questions that I can answer here? Mhm.
We did have a few questions that came in the chat, and I'll just go in the order that they came in. One of the questions is, if your SSI gets cut off due to their resources are over 2,000, will they have
Mhm.
to reapply for Medi-Cal?
If they're cut off due to being over-resourced, will they have to reapply from if it's SSI?
I believe so, if it's SS.
I think it does cut off for whatever months their Social Security is cutting off because the Medi-Cal is linked to SSI. But if you get it reinstated, then the Medi-Cal intern should also be reinstated automatically.
And then the following question, do you still receive Medi-Cal with no fees if they qualify for Medi-Cal, Medicaid as well?
Oh, like if they're on Medi-Medi. Yeah,
Yeah.
it should not, but those are more complicated questions that are dependent on um yeah, like the t different programs and living situations and things like that. Like there's asset limits, like yeah, so um in theory you can get no fees if you're on Medi, like Medicare and Medi-Cal. Yeah, you can. I've seen, yeah. Yes, but that's an individual specific answer.
And then I
Sorry if that's
think,
not very helpful.
and please too, come off mute too, if you do have any additional questions. And then another question is, will they back pay if you file after 15 days?
Yeah, so that's the risk is that they will not. Yeah.
And
You'll
then
just
the
be
last,
cut off until they find you disabled again. That's the danger of why that 15 day is very important. So read the notice carefully from Social Security. It should say whether or not this is an issue relating to 15 days or 65 days.
and then the last question, if members have applied for both SSI and SSDI and was denied for SSI, would members wait to appeal the SSI denial until after they hear from SSDI?
No, I would if the individual believes that they're also eligible for SSI, I would not wait. I would do both. Sometimes Social Security will say, "Well, we're denying you for SSI because how much you would receive based off of your work earnings is more than SSI gives, so that's why we're going to only um, keep the SSDI application pending. But if you're not sure, I always caution folks just appeal. There's no harm in filing the appeal and disagreeing, especially if you're not an attorney, you're not represented by an attorney just because you don't know any better. There's no harm in that. And then you can always talk to our office later if you have further questions about, whether or not someone is truly eligible for SSI. But remember, these are questions, whether or not you're eligible for SSI or SSDI on the non-medical side of things, that's a whole other like case assessment. The disability definition for both is the same. So might as well keep the appeal going because when they're doing the medical review, it's the same standard of medical disability. Okay. Okay. This is a question that comes up often. Can someone work when they're receiving any of these benefits? And the answer is different for each benefit. So, eligibility for SSI or SSDI is based off of their inability to engage in what is called substantial gainful activity. SGA is if someone can earn 1690 or more per month through employment, Social Security thinks that they're not disabled in 2026. However, Social Security provides certain limited protections to encourage people to try working, and each program has different policies. So for SSI, if someone's returning to work, there are rules with regard to how much benefits they can receive. So Social Security um, will count, will find someone's countable income, which is basically how much they're receiving per month, subtracting straight $85 from that monthly amount, and then dividing by two. So for example, if someone makes $700 per month at work, everyone gets the $85 deduction. So that brings them to $615. Divide that by two. $307.50 is how much your SSI will be lowered that month. In their eyes, they're trying to encourage people to go back to work. So they're saying, okay, go try and we'll lower it essentially by half of what you're making to give you that opportunity to have money from SSI as well as from your work. Know that SSI checks are sent 2 months after a client, quote, earns the SSI. So, like, let's say you've earned the money in January, you will not see that calculation reflected until your March SSI check. So the SSI check will be reduced 2 months later. So that can be kind of tricky sometimes. And when you're reviewing someone's SSI and you're trying to understand what Social Security is doing, that rule can come in and be helpful as well. If a client is working while they receive SSI, it is very important that they report their gross wages for the past month by the 10th day of the month. Again, this is one of their rules. They say that as a part of being on SSI, you agree to report any changes in your living situation or income, things like that. And Social Security, in order to avoid overpayments from Social Security, it's important to do that just on a practical level so that if you report it by the 10th day of the month, it decreases the chances of Social Security having a lag in keeping up with the correct amount of what they should be paying you. Social Security will adjust upcoming payments accordingly if you are able to report them by the 10th day of the month. Late reporting causes underpayments and overpayments, which can be a big headache for your client. Clients can take their pay stubs in person to Social Security as one way. I've known people to fax in their pay stubs to Social Security, but that can take time for processing. The best way is there is a smartphone app for SSI wage reporting where you kind of submit it directly into their portal. There's a screenshot here to the right. So you should be telling clients who are on SSI and are working to submit their pay stubs through the app to prevent overpayments. It's also important for clients to tell Social Security when they stop working too, because if they stop working, then of course they should be getting more on SSI. Okay, and here we have a hypothetical. Tony receives $1,233.94 a month from SSI and decides he wants to try working. He gets a job as a peer mentor at a local agency. In 2024, the following are his gross wages per month. You see that on the left. So some questions for the group, and please answer in the chat as you have been. Which months is Tony entitled to an SSI payment? Anyone? This is kind of a trick question. Yeah. Christian got it right, all of them. So whether or not they're on the SSI program, Social Security considers them entitled to SSI, all of them. But of course, these earnings will be reduced, will have an effect and will reduce how much SSI they are paid. So I'm sorry for the trick question. I didn't create the slide, but Tony is entitled to SSI for all of them. The next question, will Tony's SSI be automatically terminated because he works over SGA? Trying to see. Yeah, automatically meaning like next month. No, he will not be automatically terminated because he works over SGA. It might affect Tony later when they review whether or not he should be continuing to receive benefits because they'll say, hey, you were able to work for those couple of months at such a high level in their eyes. Maybe you're not actually as disabled as we thought. And yes, it will be reduced. Thank you, Richard. Also, it could trigger a continuing disability review. So maybe there was a review in their paperwork saying 3 years from now, but now he's starting to work over SGA. Ooh, that flags for them. This person is able to potentially work and is not disabled. What if Tony forgets to report these wages and doesn't remember to do so until sometime later? What do you think might happen? Mm-hmm. Yeah, he gets an OP, an overpayment notice saying, hey, you owe this amount of money to Social Security. You didn't accurately report. So now come into the office and write us a check back. Okay, so this is just to illustrate the point that someone can be on SSI and work and earn, in theory, as much as they want. But practically speaking, be cautious here because when a review rolls around, Social Security may say, hey, this is evidence that they can actually work and they're actually not disabled. Um, so um, just things to keep in mind. With SSDI, it's much more complicated. We're going to get into that here, but if you have specific case questions for a client, I really encourage you to reach out to our office because these rules are so complicated and you're going to get to see why for when you're on SSDI. If you're on SSDI, the return to work process has several steps that you have to go through. So Social Security will give you first a trial work period if you're on SSDI, then you get an extended period of eligibility, then you get a chance to get reinstated on an expedited basis, and then there's an initial reinstatement period. And all this is they're trying to encourage people to get back to work, and there's a lot of rules relating to that opportunity if you're on SSDI. Okay, so remember I said that the first thing here is the trial work period, the TWP. The TWP allows a client on SSI to test their ability to work for 9 months. All right, so during that trial work period, again, this is only if you're on SSDI, a client is going to receive their full SSDI, regardless of how high their earnings are. Totally different from SSI, because remember SSI, we just had that example where their earnings could get decreased, divided by half. No, you're going to keep your whole SSDI benefit as long as they report your work income and continue to have that conditioning, that disabling impairment. And you get 9 months to do so. And the trial work period gets triggered in the first month you earn over a certain amount in gross income. So in 2026, if you start earning over $1,210, It'll count as month one, month two, all the way to 9 months. The clients can work and earn less than these amounts without any consequence, and it won't count towards their 9 months. But as soon as they earn more, the trial work period begins. So, how long does this trial work period last? Remember, I mentioned 9 months, but it doesn't have to be consecutive. So, the trial work period continues until they accumulate 9 months within a 5-year period. So, they're saying, hey, if we tick these boxes of 9 months within 5 years, we're counting basically that, you're having trial work. And they don't have to be consecutive, obviously, if it's in a 5-year period. Medicare during this time is unaffected by the trial work period. If you earn more than those trial work period um, triggers that I just listed here, Medicare continues because they're trying to encourage people to go back to work. If income goes up, they may be ineligible for certain Medicare subsidies, however. Okay, so we have a hypothetical here. Gina's work earnings in 2026 are on the left as follows. So in January, she earned 1,200, in February went down to 200. Maybe she made a little bit more in March. So what are Gina's trial work period months? What months are they going to start counting towards those 9 months that she has? And remember, in 2026, the limit is $1,210. Oops. Oh, it's doing that. Okay. So the trial work period months are anytime it's over $1,210 in 2026. So the first time that's occurring is in March when she's at $1,600. And the next time is in December when she's over 1,210. All right. So has she here accumulated 9 trial work period months yet? No, not yet. But she's getting there. Just 2 months exactly. Thanks everyone for being so active in the chat. I really appreciate that. All right, so next we have an extended period of eligibility. So once someone's ticked off all 9 months within a 5-year period, Social Security says, okay, we're going to give you also an extended period of eligibility before we cut off any sort of SSDI funding. So the extended period of eligibility is all or nothing, like an on-off switch. So if a client earns above SGA, in that time, they'll be no longer eligible for SSDI just for that month. So we really advise clients to try to keep their gross wages lower just to be on the safe side. There's also a 3-month grace period. I wouldn't worry too much about that, but just so you know, one exists where SSDI payments continue in the first month, and then when you have earnings greater than SGA, and also they'll give it to you, your SSDI payments for 2 more months. So you'll get 3 months worth of SSDI. But if your earnings drop below again during the 36-month extended period of eligibility that exists, and it's just 36 months for everyone, then they can restart. So they're trying to say, hey, if you drop back down, we'll give you SSDI for that month. So again, it's an on-off switch. Overpayments are common here. It takes Social Security time to process your work activity, and the rules are super confusing in this area. So just as a tip, clients should keep copies of all their pay stubs. And of course, submit them by the 10th of the month, the next month, to Social Security. Okay, what happens? Um, let's see. Uh-oh. All right, so here we have a hypothetical of extended period of eligibility. Gina's 9-month trial work period expires in December 2023. So in 2026, she actually earned the following amounts at work on the left there. What months did Gina go over SGA? That's 1690. Substantial gainful activity amount for 2024 is 1690. So what months did she go over such that they're going to turn her SSDI off? February, April. Mm-hmm. Exactly. So February and April, they will turn her SSDI off. In what months was she entitled to an SSDI payment? The inverse, right? Every month where she wasn't earning above that 1690 amount, yeah, she'll get an SSDI payment. All right. And those are the rules during the extended period of eligibility. And this is all basically tapering out to say, hey, does this person really need to be on SSDI anymore? We're going to give them multiple chances to try to work without completely taking away SSDI. If after the 9-month trial work period and 36-month extended period of eligibility occurs and Gina works over SGA, at that point, they will stop her SSDI. And when it's terminated, and she wants to get back on, it's not an on-off switch anymore. She will have to reapply. You may have to go to an administrative law judge hearing, things like that. So it's basically she'll have to start all over again. At this point, oh, I'm so sorry. Before that occurs, oh, I'm sorry, I misspoke. I forgot about the expedited reinstatement. So not yet. We're not there yet at starting all over. At that point, if it's terminated, there's something called expedited reinstatement. So if her wages drop below SGA within the 5-year period after this 36-month extended period of eligibility, she asks for something called expedited reinstatement. It's a new application, but it is faster than an actual new application because they will use less strict standards when they're reevaluating. So it's not like starting completely from scratch. After someone applies for expedited reinstatement, EXR, Gina can receive up to 6 months of provisional benefits while her application is pending. So they'll just give her 6 months, free. Here, we'll just keep you going while you're applying to get back onto Social Security disability income, and it's supposed to be a more less strict process. If the application does take more than 6 months, however, she does not get payments during those months. If Gina's expedited reinstatement request is approved, then a new cycle of the TWP, trial work period, an extended period of eligibility begins after 24 months of SSDI payments. Okay, and that's called the initial reinstatement period. So many terms, it's not something that you need to necessarily worry about. It's more just we want you to be familiar with that concept of returning to work rules and how it is so vastly different if you're on SSI versus SSDI.
Annie, we have a
Mhm.
few clarification
Sure.
questions. One, is the 36-month period immediately after the 9-month period? In the last example, the 9 months ended in 2023, and then the extended period of eligibility was in 2026.
Yeah, so it's 9 months within a 5-year period. So they don't have to be consecutive. The 36 months of EPE that's triggered the month after the 9th month, those are consecutive. It's very confusing. Does that answer your question? Please chat me if it's not, if you still have questions.
And then it was another question, if it's not approved, does she have to give the money back?
That is a really good question. I would say generally no. If you are in good faith appealing and saying, I still am applying for SSDI or SSI because I really do believe I have a disability, generally no, you don't have to pay it back. But that doesn't mean that they can't, say for some reason that, there's always scenarios that Social Security could come back and say, actually, you did know, or you really shouldn't have reapplied. But generally speaking, I would say the law protects people who are trying to apply for disability in that specific scenario of, in good faith, they really can't. They really didn't think that they could work. Okay, then we have some wage reporting tips for folks on SSDI. Again, it's best to proactively report the wages to Social Security to, of course, avoid overpayments. And then the ways to report are the same. Best way, in my opinion, is through reporting online, but there's no app for SSDI recipients to report wages. They have to do it through My Account. So they create a My Account on ssa.gov. You can also walk in and to like put in your pay stubs to the field office, but again, that will increase their processing time too, because someone now has to get the pay stubs and it may sit on someone's desk. So don't recommend that if at all possible. Sometimes it's unavoidable. Sometimes people really don't know how to use, online accounts and things like that. But if they can at all, or if you can help them, that's the best way to avoid overpayments. And also remember to report when your work stops. That way they're not getting underpaid either. And report the income when it is earned. Hopefully I've made that clear by now. I always tell clients never try to hide it from Social Security, especially if it's, via pay stubs, it's not under the table. It's all linked to your Social Security number. They will find out about it eventually through various auditing reports they have. It's connected with the IRS, it's connected with various employers. So they have ways of auditing people who aren't reporting. And Social Security also, oh, right here, conducts periodic work reviews and will pull IRS records. Um, Social Security will find out about all taxable income at some point, regardless of whether a client reports it, and it could result in huge overpayments and or suspension of benefits. So it's better to just do it as it comes, report it as you're getting paid. Okay. Any questions here?
Yeah, and we did just get one question in the chat. If someone gets overpaid but still eligible to benefits, can the overpayment get taken out of the remaining benefits?
Sorry, can you repeat that one more time?
Yeah, if someone gets overpaid but
Mhm.
still eligible to benefits, can the
Mhm.
overpayment get taken out of the remaining benefit?
Yeah, like a withholding. Yes, it could. And so if they disagree with that overpayment, then it's really important to file that you disagree so it stops any withholdings from your current benefits. Good question. Let's join back in. Thanks everyone for coming back from break. Hopefully everyone had a good break. Now we're going to be going over overpayments and how they occur, as well as what to do if you get one. Overpayments can occur for various reasons. SSDI overpayments are typically caused by an individual going back to work and then earning more than the substantial gainful activity limit. This occurs after a person has used up their trial work period. Overpayments, SSI overpayments, on the other hand, can be caused by a change in your living arrangements, change in your income, having excess assets, resources, leaving the country, or becoming incarcerated. So any change to your living arrangement can also lead to overpayments. For example, being in the hospital for more than 30 days. If you see that someone receives a notice of overpayment, they do have a right to challenge that overpayment and disagree. They can file a request for reconsideration. This is basically saying, hey, I disagree either with the amount of the overpayment or with the fact of the overpayment itself. You can file a request for a waiver of overpayment. This can be either or both. So you're saying, okay, fine, I agree even with the fact of the overpayment or the amount, but even if that's true, because it would be a great hardship to me, or because I cannot afford to pay it back, or because I'm disabled in some way, I request that it please be waived. And then the third option is also to request a change in repayment rate. And all these can be filed in conjunction with each other. There's strategic reasons why you may want to file all three or only two or just one. So these are things that if you have questions about, please refer folks over to Law Foundation and we can try to help. In order to file a request for reconsideration, that's the request saying that I'm challenging that decision of an overpayment. The deadline is 65 days. So just the typical 60-day, and then they give you a 5-day grace period for mailing. You're going to count the days from the date on the notice. So it's really important what that top corner says, as far as what day they generated the notice. And a request concerning an overpayment can be filed again if you disagree with the fact that you were overpaid or with the amount of the overpayment. Social Security will take another look at the reason for the overpayment and the calculation if you file a reconsideration request. The client may be entitled to a personal conference with Social Security to discuss the overpayment. And typically, this personal conference occurs in person. It can occur by phone, but if you want a personal conference in person, that can happen. And Social Security is supposed to give you a different individual than who made the decision the first time. So you're getting someone else new to look at your case. If Social Security denies your request for reconsideration, the client is then entitled to ask for a hearing with an administrative law judge. And you also have to invoke that within 65 days. Just a little bit about requesting for a waiver or a change in repayment rate as opposed to a reconsideration. The client can file a request for waiver of overpayment or for change in repayment at any time after the notice of overpayment, even if they've already begun paying back the overpayment. So it can be years later after they've gotten an overpayment that they say, oh, I actually want it waived. So there's no 65-day deadline for requests for waivers or a request for a change in repayment rate, which is really good for a lot of folks who maybe didn't know what to do at the time they received the overpayment notice. A request for waiver of overpayment can be filed if the client is not at fault for the overpayment and cannot afford to pay back the overpayment. A request for change in repayment rate should be based on showing Social Security how much the client can pay towards the overpayment payment based on their income and expenses. So they will have to delineate how much they're receiving in any income and how much their expenses are month to month. For SSDI overpayments, Social Security aims to collect the overpayment within 36 months. This means that Social Security takes the amount of the overpayment and divides that by 36 months to determine their ideal monthly repayment rate. With respect to SSI overpayments, Social Security defaults to a withholding of 10% of the SSI benefits. So even if they don't answer or respond in any way, just Social Security will automatically start withholding 10% of their benefits to pay back that overpayment. However, clients can often negotiate repayments as low as $20 per month and just have that quantity set if they can show that they cannot afford to pay back the overpayment at a higher rate. If Social Security denies the request for a waiver and/or your request for a change in that rate of repayment, the client is entitled to ask for a hearing on those grounds as well. So just because they're requesting a waiver or change in repayment rate, doesn't mean that they can't escalate it all the way up to an administrative law judge on appeal. The deadline for request for a hearing is always 65 days for mailing once you get a denial from Social Security. 65 days are based on the date of the denial notice. So again, looking to what the notice says, the date of their denial is. And here we have a hypothetical. Sarah receives SSDI benefits in the amount of $900 a month and SSI benefits in the amount of $333.94 for a total of $1,233.94 in monthly Social Security benefits. So this example is an example where someone's getting concurrent benefits. You can get both SSI and SSDI benefits. Sarah gets married. Does she need to report her marriage to Social Security? What do folks think? I'll open up the chat. Yes. Does anyone want to come off the chat and say why?
I think it has to do with the change in the living situation.
Exactly. Yeah. Change in marital status does affect how much Social Security you do get. Um, They expect if you legally marry to someone, or even if you don't, it's very tricky. If you hold yourself out as married, even if you're not legally married, they will count that as marriage as well. They expect your partner to help you pay for expenses, so you do need to report. It will affect the SSI amount that Sarah is receiving. Thank you for coming off chat. While Sarah's disabled and cannot work, her husband has a job and receives monthly paychecks. Does Sarah need to report her husband's earnings to Social Security? Anyone want to come off chat and tell us what they think? There's no wrong answer here. We're just brainstorming right now. Okay, well, similar to marriage, Sarah will need to report her husband's earnings to Social Security. This is because there's spousal deeming rules. Again, they expect a partner to support you, and so it will affect how much she receives in SSI and could cause an overpayment if she does not report. Sarah was previously married to an abusive spouse who lied and told Sarah that he was not working and did not have any earnings. She continued to receive SSI benefits for the duration of that marriage. So once Social Security learned about her previous marriage and her current marriage, her ex-husband and her husband's wages will likely impact her SSI. If she receives an overpayment notice, though, what options does she have here?
She could ask for a reconsideration and then kind of explain the circumstances of, being in an abusive marriage and that, you know, that basically she was being lied to about it. So she didn't know that she had to report it.
Absolutely. Yeah, you could file reconsideration and say you disagree. You're being actively lied to. She was restricted access to the records, so she didn't even have access to the records potentially if it was an abusive relationship. How about if she files for a waiver? What arguments could she make with that scenario that I just talked about before? The waiver again says, hey, I admit to being overpaid, but even as such, I think it should be canceled.
She could still use the same arguments as for the reconsideration because she's admitting it, but she didn't know till after the fact.
Absolutely. Yep, you're exactly right. Thanks, Christine. So you could say the debt is not her fault. The repayment, had it been a marriage where she knew about it, she would have, obviously paid it if she could. So she was not trying to lie to the administration. And repayment at this point would cause her financial hardship, as she is also on SSI. Her SSDI benefits were not enough to bring her up to the SSI minimum rate. That's why she's getting some SSI benefits in the amount of $333. Thanks, everyone. Any questions here? Okay, so wrapping up a little bit, in conclusion, if there's ever any doubt, just send them over to our office. We're so happy to help. Even if we can't sign a full representation agreement where we're saying, yes, we're going to go with you to hearing and present your case before the administrative law judge, we often can provide referrals or even give legal advice prior to going if they need to go on their own. Hopefully not. Fingers crossed there's someone who can take on their case. For initial eligibility appeals, so this is someone who's applying for SSI and SSDI for the first time. We will assist clients with filing appeal paperwork at both the reconsideration and ALJ stages, so the administrative law judge stages. So we don't help with, I think what this point is trying to make is that we don't help with the first application. Like we won't sit there and do an application with them. That's something they can do with Social Security if they want to, or hopefully an organization that you know about, but we really come in when there's a legal problem, when someone has told them no. And then we will do a merit review to assess whether or not we can actually represent the client. But don't wait for us to sign on to a case before realizing, hey, there's a 65-day deadline. Either you can help them or you can flag it for us and say, hey, a 65-day deadline is coming up, so that even as they're waiting for us to review the case, they're not losing out on their rights. For most cases at the reconsideration level, we assist clients with filling out the appeal paperwork and ask them to come back if they're denied. And then, if they are denied and need to request an ALJ hearing, we'll help them do that. So we're not necessarily representing them full scope at reconsideration either. The Law Foundation also, like I said, does not assist with filling out initial applications. All right, we also have case services for when folks are terminated from their benefits. Again, not really at the initial reconsideration stages, although we always try to help make sure that their rights are protected, so helping them file for that appeal. But at the ALJ stages is more when we can sign on, just because there's such a need for representation at that stage, and there's so many people needing that help. So we're just severely impacted. And remember that 10-day deadline, technically it's 15 with 5 days mailing for clients to appeal CDR, continuing disability review terminations, in order for them to continue to receive benefits during the appeal. If the 10-day deadline is approaching, it's best to just send the client directly to Social Security to appeal in person and get a receipt that, okay, I did file, so that their benefits do not terminate. You can refer benefit reductions to our office as well. We can look into that. Again, at initial and reconsideration, it may be harder for us to sign on depending on the circumstances, and we're hopefully more able to take on cases at the hearing stage. With overpayments, you can refer all overpayments to our office as well. Due to resource limitations, again, we prioritize overpayments that are in excess of 10,000, but we can certainly provide some advice too regarding, overpayments that are lower. Also know that there are administrative waivers that you can file for overpayments that are in the amount of $1,000 or less. The agency will just waive those if you ask them to. But anything in the middle range, 1,000 to 10,000, still come to us, but we may not be able to prioritize their case just because we're seeing so many clients with very, very large overpayments that have a great need to deal with those. Just as a caveat, we can't guarantee full representation to all clients in all matters. For all cases, we do try to conduct a review before agreeing and provide as much service as we can. So if it's not full representation, we try to provide counsel and advice or limited services like, okay, we'll help you fill out this paperwork. Not necessarily legal, but if there's no one else out there to help, then we'll try. Which is why your work is also so important too, because we're trying to serve the community as much as we can, but we really can't do it alone. And then also, obviously, we represent clients at the administrative law hearing stage, appeals council, and federal district court hearings as well. So very impacted. Here are some ways to refer clients to the Law Foundation. I know that this is going to be emailed out later, so you'll all have that. But you can fax, email, online. They can call our intake line or walk into our office during Tuesdays and Thursdays from 1 to 3 p.m. Or they can see us in person at an Alexian clinic too, VHHP, the last Friday of the month. So basically, there's no wrong way to get a hold of us. We just try to keep our doors open as much as possible for different methods. But that is the end of the presentation. I will stay on for, as long as folks still have questions, I don't mind. But thank you so much for your time.
We do have one question. If a client goes past a 65-day deadline, do they have to start over?
Not necessarily. There's good cause that can be requested. So you could say, oh, maybe the client didn't receive their mail until the 60th day or something like that, or they're unhoused, or they were really sick this month. They were in and out of the hospital. Even if they weren't in and out of the hospital, they're unrepresented. They didn't know how to do this and file an appeal. So there's different ways. I wouldn't give up just because they're over the 65-day deadline, but it is an additional hurdle that you'll have to get through. So it's always easier if you haven't missed the deadline yet, help them file for an appeal. But if they are over, there are ways to overcome that deadline.